Welcome back to Criminal Law, everyone. I hope everything's going well. And I hope that you're feeling good about your classes this semester. In particular, I hope you're feeling good about what we've been doing in criminal law. Just a reminder that I love questions and I love meeting students. So consider dropping by my weekly office hours sometime. I'd love to see you. This recording is the third lecture of the semester on something called the Legality Principle. It covers the final topic in our first Foundations of Criminal Law module. So now is as good a time as any to ask, where are we exactly? And how do we get here? Let's take a moment to recap. In the first lecture of the semester, I introduced you to the topic of criminal law. During that lecture, we covered some of this class's most central themes and concepts. We discussed the criminal law's basic structure and primary sources. And we explored some of the most important differences between criminal law, civil law, and criminal procedure. Then in class, we covered one procedural aspect of the criminal law that plays a particularly important role in criminal cases, the requirement of proof beyond a reasonable doubt. Then came the second lecture, where we explored some of the most important policy ideas that animate the criminal law, what we call the principles of punishment. As we discussed, these principles are the primary reasons that exist for creating new criminal laws, for reforming or getting rid of old ones, and for determining punishments. During that lecture, I focused on 5 main policy principles: retribution, specific and general deterrence, incapacitation, rehabilitation, and moral communication. Although these principles don't provide precise answers to criminal policy questions, they can help us understand the U.S. criminal law because of how much they influence 2 different legal practices. The first practice we focused on is criminal lawmaking. That's where elected representatives use these principles to justify bills that would alter the scope of criminal liability and punishment in U.S. codes. The second practice is criminal sentencing, where judges and the attorneys who want to persuade them use principles like retribution, deterrence, and incapacitation to justify particular punishments in specific cases. As we discussed, this is sometimes legally required in jurisdictions with statutes that mandate the consultation of punishment principles. So between shaping what we prohibit and how we sentence, punishment principles have a significant impact on U.S. criminal law. But they're not the only principles that matter, because there's more to the criminal law than rules and punishments. There are also important questions about how the substantive criminal law is created and how it's interpreted in a constitutional democracy. These kinds of process issues are one step removed from the more immediate questions about criminal punishment we discussed in the last lecture. But they ultimately play just as important of a role in helping us understand the criminal laws we live with today. For example, consider a really basic question. Who should make the criminal law? That is, should criminal law rules be developed by judges, most of whom are unelected, in the context of individual cases and judicial opinions? Or is it better for criminal law rules to be made by our democratically elected representatives, who can study criminal policy problems in hearings and then try to solve them through general legislation? So over time and throughout history, jurisdictions have given different answers to this question. In today's lecture, we're going to discuss the shift in support from a judicially driven approach to criminal lawmaking towards a legislatively focused approach. And we'll carefully study the criminal law's most important process principle, what I'll refer to as the principle of legality, which drove that shift. We're then going to use this legality principle to help us understand one of the most impactful legal practices in a world of criminal legislation, that's statutory interpretation. Because words are imprecise and many statutes are poorly drafted, criminal offenses frequently fail to provide a clear answer in many situations. So an important part of what both criminal courts and attorneys do is argue about the meaning of criminal statutes. In today's class, we're going to study how that argumentation happens in U.S. courts and how legal debate has been shaped by the legality principle. Most important, we're going to learn a 3-step method of statutory interpretation which provide a common language for crafting arguments about the meaning of criminal statutes. Finally, at the end of this lecture, we're going to discuss an important constitutional limit imposed by the legality principle on statutory drafting, the void for vagueness doctrine. At some point, a statute can be so unclear that it fails to provide a person of ordinary intelligence fair notice of what's prohibited. Or just as bad, A statute's vagueness may be so severe that it leaves police and prosecutors with discretion to enforce a criminal law against just about anyone for just about any reason. Under these circumstances, courts can strike down a statute as a violation of the Due Process Clause. As we'll discuss, this void for vagueness doctrine is inconsistently enforced and is itself pretty vague. But it still helps us understand the limits of legal drafting and criminal enforcement in the United States. Okay, so that's the plan for today's lecture. In covering this material together, I hope that we'll be able to accomplish 4 key learning objectives. The first is to understand the legality principle, both what it is and what it has to say about the creation and interpretation of criminal statutes. Second, I want you to be able to appreciate the differences between criminal law made by legislatures and courts, as well as the big impact that the Model Penal Code has had on U.S. criminal legislation. Third, I'm going to introduce you to the topic of statutory interpretation. In the process, I hope you will be able to appreciate why criminal statutes need to be interpreted and how to apply the 3-step approach to statutory interpretation that we'll be using throughout the semester. Fourth and finally, I want you to understand the constitutional limits imposed by the legality principle on the creation and interpretation of criminal statutes. So, as I think you can tell, there's a lot to accomplish in today's lecture, which I want to note covers the equivalent of 2 full lectures. To help simplify things, I've condensed both of those lectures into a single recording. But as always, you should feel free to hit pause and take breaks whenever you feel like it. Sound good? I hope so. So with that, let's go ahead and dive in. In today's lecture, we're going to focus on 2 very important legal practices: the creation and interpretation of criminal statutes. Just about everything we're going to learn about today is in some sense traceable back to a single idea, what's often referred to as the legality principle. So let's begin by introducing the idea. In simplest terms, the legality principle is the requirement of previously defined conduct. The idea is like this: some conduct is immoral or harmful. Some conduct is criminal and punishable. But the fact that conduct is immoral or harmful doesn't necessarily mean that it's criminal and punishable. Because generally speaking, a person can't be punished in the US unless her conduct was defined as criminal before she acted. Another way of saying this is that there's a bar on retroactive lawmaking in the United States. This prohibition on retroactive criminal lawmaking is understood to be the essence of the legality principle. And it's also part of the US Constitution in 2 different places. The first prohibition on retroactive lawmaking can be found in Article 1, Section 10 of the US Constitution. That section prohibits federal and state legislatures from enacting ex post facto, which is to say, after the fact, legislation. This ex post facto prohibition specifically limits the legislature from enacting laws that either punish conduct that was lawful at the time of its commission or that increase the punishment for an act committed before the law took effect. Let's consider a couple of illustrations. Keith drinks beer on January 1. On January 2, the legislature criminalizes alcohol. Keith is then convicted on January 3rd for his January 1 conduct. On these facts, Keith's conviction would be an unconstitutional violation of the ex post facto clause. Here's another example. Katie commits murder, an offense punishable by life imprisonment, on January 1. On January 2, the legislature decides to pass a statute allowing the death penalty for the offense of murder. On January 3, Katie is sentenced to death for her January 1 conduct. On these facts, Katie's sentence would be an unconstitutional violation of the ex post facto clause. Okay, so that's one way the legality principle places constitutional limits on retroactive lawmaking by legislatures. Another way is through the Due Process Clause of the 5th and 14th Amendments, which limits retroactive lawmaking by judges. Specifically, the U.S. Supreme Court has interpreted the Due Process Clause to bar courts from unforeseeably expanding the scope of criminal statutes to retroactively criminalize new forms of conduct. It's important to note that this due process constraint on judicial decision-making is a looser one than the ex post facto clause imposes on legislatures, because the line between unforeseeably expanding the scope of a statute and merely interpreting it can be a blurry one. But at the very least, it's clear that under the Due Process Clause, courts can't retroactively apply an offense by inserting or deleting words, or by giving the terms used in a statute false or unusual meanings. A good illustration is provided by the Supreme Court's decision in Bowie v. City of Columbia, which is discussed in the Keeler decision you've been assigned. So the Bowie decision focuses on a criminal trespass statute, which prohibits one person from entering the lands of another person after they've been given notice that they may not enter. The defendant in Bowie was convicted for violating this do not enter trespass statute in a situation where he was actually allowed to enter, but then chose not to leave after being given a do not stay notice. The US Supreme Court ultimately reversed the conviction, holding that the unforeseeable expansion of a do not enter trespass statute to a do not stay trespass situation constituted retroactive judicial lawmaking in violation of the Due Process Clause. These dual bars on retroactive lawmaking are considered to be the essence of the legality principle, which many in turn believe to be the most fundamental principle in all of the criminal law. What do you think all this fuss is about? Is retroactive lawmaking really that wrong? Intuitively, I think that applying new criminal policies to prior conduct rubs me and many other people the wrong way. But there are also reasons to support the feeling. In the last class, we discussed some of the most important first-order policy reasons that exist for justifying punishment. If you can, pause the recording for a minute to think about how those punishment principles might support a ban on retroactive lawmaking. As you reflect, consider whether there might be any other reasons beyond those punishment principles that stand against retroactive lawmaking. Okay, welcome back. So what might the principles of punishment have to say about retroactive lawmaking? Let's start with retribution. Retribution says that we should punish people because they deserve it, and that deservingness is a product of two factors: harmfulness, or the bad act, and culpability, which is the guilty mind behind that act. So from a retributive perspective, the fact that a harmful act isn't criminalized doesn't make it any less harmful. But the fact that someone engages in that conduct, believing it to be illegal, very well might. Because in that case, they wouldn't have actually chosen to violate the law, and for retributivists, choices matter. So retroactive lawbreakers' minds may not be blameworthy enough to deserve punishment. Or at least that's an argument that could be made. Okay, now let's evaluate retroactive lawmaking from a utilitarian perspective. As you might recall, utilitarian punishment focuses on controlling crime through 5 different pathways of public safety. One of those pathways is general deterrence, which essentially says that if we threaten terrible consequences for engaging in certain forms of conduct, people will think twice before engaging in them. But of course, for deterrence to work, this threat of punishment has to exist before the person engages in the conduct, not after the fact, as retroactive lawmaking might otherwise allow for. And that's a fundamental problem for deterrence, which views rational cost-benefit decisions as the key to controlling crime. Basically, if there's no law in place at the time someone acted, then there's no way for people to incorporate the cost of violating the law into their decision-making calculus. All right, punishment principles provide one set of justifications for prohibiting retroactive lawmaking. But there are other justifications which speak more directly to the rule of law concerns at the heart of the legality principle. So one of those concerns, which you'll hear quite a bit about in this lecture, is fair notice. That's something that many consider to be the foundation of any reasonable legal process, but particularly one that involves punishment. In a criminal system where incarceration is possible, people need to be able to trust that if they follow the rules, then they'll be safe from being incarcerated, or from suffering any other form of aversive government action. But if people can be convicted for violating the rules without fair notice of what those rules actually are, well then, that sense of trust is destroyed. Simply put, a world where the government can knock down your front door and place you in a cell with prior warning is a world of fear. A lack of fair notice leaves everyone in a state of uncertainty about what might happen to them. Now, some might say, look, there's no need to worry here. In the US, we can just trust the government to do the right thing and to get the right people. But over time and throughout history, we've seen the incredible penchant of all governments, including our own, to engage in tyranny and abuse. So there's arguably independent value, aside from fair notice, on limiting government authority. In our constitutional democracy, we need the government to keep us safe. But we also need to make sure that the government is kept in check and doesn't become too powerful. The legality principle views the bar on retroactive lawmaking as one important way of accomplishing that. So that's an introduction to the legality principle. In short, it's a principle that specifically prohibits retroactive lawmaking by legislatures and courts, and it's an idea that emphasizes rule of law concerns like fair notice and limited government. So far, so good? I hope so. With that, now we're going to take what we've learned about the legality principle and use it to study two important criminal practices: the creation and interpretation of criminal law. Okay, who should create the criminal law? For every criminal policy decision, there's a choice about who makes it: legislators or judges. This semester, we've already seen how legislators can make criminal policies by enacting criminal statutes. It's important to note, though, that courts can just as easily announce a criminal policy through judicial decision, subject to constitutional limits. And indeed, for much of Anglo-American legal history, judges did just this, creating a whole bunch of criminal policy on their own in both the UK and the US. So, for example, prior to the founding of this country, English judges routinely issued criminal policies through judicial decisions on the basis of general principles and long-standing customs. This so-called English common law provided the foundation for US criminal law. But after American independence, US courts quickly started to modify English common law through their own judicially declared criminal policies. As time passed, though, judge-made criminal law developed a pretty bad reputation. There were many reasons for this, but one of the most important was a growing appreciation of the legality principle. Simply put, in a world where criminal policies can be made by judges or by legislators, the legality principle strongly favors a legislative approach to criminal lawmaking. But why? Well, let's return to the values of fair notice and limited government we just discussed for some insight. In terms of fair notice, criminal statutes have some important advantages over judge-made criminal law. First, criminal statutes are more accessible to the public. That is, criminal codes provide a single, organized compendium where members of the public can go to read about what you need to do to avoid being punished. By contrast, collections of judicial decisions are far less accessible, and so they do a much worse job at relaying criminal law rules to your average person. But look, the fair notice argument in support of criminal statutes goes far beyond sheer accessibility. The reality is that legislatively made criminal law is also a lot more uniform and predictable than judge-made criminal law. On the one hand, legislators can study a criminal policy problem in advance and then engage in a coordinated effort to comprehensively address all relevant issues in a single piece of legislation. By contrast, courts are limited to dealing with issues as they arise, and so can only make criminal policies piecemeal. Moreover, because there are many lower courts, there's a risk that different judges will provide different answers to the same policy issue unless and until the highest court steps in to impose some uniformity. So, because legislatures are more centralized and organized, they're better situated to produce the kind of clear and consistent body of criminal policies that fair notice depends on. Okay, so that's fair notice. Now let's consider a limited government explanation for leaving the creation of criminal policy to legislatures. This explanation is grounded in something called the separation of powers. The separation of powers is a constitutional principle which basically says that we can promote liberty and protect against government tyranny by keeping each branch of government in their lane. On this vision of limited government, we should leave it to legislatures to make the law, to prosecutors to enforce the law, and to judges to interpret it. By separating powers in this way, the idea is that no government actor will be too powerful and we'll all be better off. These and related ideas about legality played a pivotal role in the creation of the Model Penal Code during the mid-20th century. Spearheaded by the American Law Institute, a group of prominent judges, lawyers, and law professors decided to draft a model code that legislatures could use as a basis for a comprehensive code. Through that work, the drafters of the MPC attempted to provide legislators with a way to clearly communicate the most important criminal policies governing in their jurisdiction. And in the process, the MPC drafters hoped to supplant the need for judge-made criminal law, which had been the source of so much confusion, inconsistency, and unpredictability during the first half of the 20th century. So the American Law Institute's MPC drafters went through 13 tentative drafts and accompanying explanatory commentaries before they finally approved and published a proposed official draft of the Model Penal Code in 1962. Release of that code set off a wave of criminal codification efforts which fundamentally reshaped U.S. criminal law. Although the code isn't the precise law in any jurisdiction, in the 2 decades after the MPC was released, 34 states adopted comprehensive criminal codes based on the MPC's recommendations. And even the minority of jurisdictions which were never able to adopt a comprehensive code, courts still frequently rely on the Model Penal Code as the basis for resolving criminal policy issues that their legislatures failed to address. More fundamentally, the Model Penal Code often provides a starting point for many of the most important criminal policy debates. And it's also responsible for ingraining the legality principle into the architecture of modern criminal law. One important illustration of this fact is the largely successful effort to abolish common law crimes in the United States. The drafters of the Model Penal Code recommended that jurisdictions bar courts from making up new crimes or recognizing old ones through judicial decisions. Many states have since agreed, choosing to enact criminal statutes that abolish the practice of common law crime creation by limiting criminal liability and punishment to legislative enactments. Consider, for example, California Penal Code Section 6, which states that no act or omission is criminal or punishable except as prescribed or authorized by this code. Even in jurisdictions without these kinds of statutes, judicial crime creation remains extremely unpopular and disfavored for the legality-based reasons we've been discussing. Okay, so that's the creation of criminal law. Now we're going to turn to the interpretation of the criminal law, both how it happens and what the legality principle has to say about it. But before we get into the details, I want to take a step back to discuss the kinds of problems that make statutory interpretation such a necessary and important part of U.S. criminal practice. U.S. criminal statutes often need to be interpreted because they suffer from 2 key problems: vagueness and ambiguity. In plain English, these words are synonyms. They both indicate a lack of clarity. But there are actually 2 distinct ways in which a statute can be unclear. And in the world of legal practice, there's an important difference between those 2. Let's start with the problem of vagueness. A statutory term is vague when its general meaning is known, but the boundaries of its meaning is unclear. Which is to say, for a vague term, there may be many situations where we know the term applies, but there will also be borderline cases that are very hard to classify. So for example, in the Keeler case you'll soon read, there's a dispute over the meaning of the phrase human being in a homicide statute. No one disputes that a newborn baby is a human being for purposes of homicide. But what about a fetus growing inside of its mother? Is killing a fetus inside a mother's stomach killing a human being for purposes of homicide? That's one kind of vague problem. For a less grisly example, consider the term attempt when used without a legal definition. So I want you to think of a statute that generally prohibits anyone from, quote, attempting to rob a bank, where the term attempt isn't defined. Even without a legal definition for the term, we know that this statute would cover a failed bank robbery scheme carried out in its entirety. So for example, imagine a masked robber who forces the bank teller to open the safe, but it turns out nothing's inside. If attempt means anything, it's that someone who does everything necessary to commit a crime but is unsuccessful must have attempted to commit that crime. Okay, but there are also many boundary cases which the ordinary meaning of the term attempt fails to clarify. For example, is an attempted robbery when someone with a gun and mask is arrested in the nearby parking lot right before they step out of their car to rob a bank? Or what if this would-be robber was arrested even earlier in the chain of events, like right after they purchased a mask and gun? Is that kind of substantial step towards the completion of offense enough? Or do people need to come dangerously close to completing their plan to be subject to criminal liability? So this is a really interesting criminal policy issue that we'll study later on this semester. For now, I just want you to be able to appreciate that we don't readily know the answer because the term attempt is vague. So resolving a case that implicates the boundaries of a vague statutory term or phrase like attempt requires interpretation. The same is also true of an ambiguous statutory term or phrase, but for different reasons. Statutory ambiguity arises when a term or phrase can be understood in 2 or more ways. Here's a simple everyday example. Imagine that we're on a Zoom call. I'm in Miami and you're in California. At the end of the call, I ask you to call me at 3 p.m. tomorrow. You kindly agree, and then we both leave the meeting. But wait a minute, when's our next meeting actually supposed to happen? Is it at 3 p.m. Miami time or at 3 p.m. California time? Either answer is possible because the phrase, call me at 3 p.m. tomorrow, is ambiguous. That is, we know what the words mean, but they're susceptible to more than one understanding. Now let's consider a statutory example of ambiguity. Imagine a criminal law that prohibits, quote, knowingly causing bodily harm to a child. On first read, this statutory language might seem relatively straightforward. But there's actually an important ambiguity hidden beneath the surface that relates to mens rea, or the guilty mind. On the one hand, the enumerated culpable mental state of knowingly could be interpreted as applying only to the result element of causing bodily injury. In that case, all the government would need to prove to secure a conviction is that the defendant was aware that his or her conduct, say for example throwing a rock at someone, would cause bodily injury. Now, on this reading, it would be immaterial whether the accused was aware that the victim was a child. But another reading of the phrase knowingly causes bodily injury to a child is possible. The knowingly mental state could be read to apply to both the result element and the requisite circumstance element. In that case, the government would need to prove both that the defendant was aware that his conduct would cause bodily injury and that he was aware that the victim was a child. Under this narrower reading of the statute, a mistaken belief that the victim of assault was an adult, rather than, say, a very tall child, would provide a defense to liability. So the choice between the two readings of an ambiguous statute matters, and it can only be resolved through interpretation. But how should that legal interpretation take place? Well, this is a really important question because of how common vagueness and ambiguity are in U.S. criminal statutes. And it's a really difficult question because there are very different methods that courts might apply to derive meaning from criminal statutes. One possibility is what we might refer to as the judicial lawmaking model of statutory interpretation. The idea here is that courts should use their own policy preferences or ideas to fill in the gaps of statutory meaning left by vague or ambiguous terms. So, for example, if the legislature uses the vague phrase human being in a homicide statute, then the court should consider which interpretation of the phrase would best serve the retributive and utilitarian goals behind the criminal law. There are some judges who embrace this common law method of interpretive lawmaking. Take a look, for example, at the dissent in the Keeler case you'll soon be reading. But on the whole, that method has largely been rejected in the US as inconsistent with the legality principle. One problem is that allowing judges to broadly interpret statutes to promote their own policy preferences fails to provide people with fair notice. Another problem is that asking judges to serve as a junior varsity legislature whenever a vague or ambiguous term is used violates the separation of powers and the idea of limited government. Okay, so that's why the legality principle rejects the judicial lawmaking model of statutory interpretation. But what kind of method does it support? That method, which is one that just about every judge in the country accepts, is one focused on legislative intent. The idea behind this common method is simple. Legislatures, not judges, are responsible for making law, so judges should limit their interpretive focus to figuring out what the legislature intended, not what courts want. Now, let's consider what this means in practice. The starting point for reading a criminal statute under this intent-based approach is the plain meaning of the terms used. Because after all, the plain meaning of statutory terms is what the public's on notice of. And it's also presumably what the legislature intended to enact into law. So it's what courts first looked at. Under this so-called plain meaning rule, judges first resort to the exact wording of the statute and will try to read statutes in a very literal way. If the plain meaning of a statute's clear, then that's the end of the interpretive enterprise. However, when the plain meaning of a statute isn't clear, as is often the case, then courts move on to the second step of the interpretive process. Here, judges consult 3 different sources of statutory meaning, each of which can provide an important indication of legislative intent. The first source is something called legislative history. These are materials surrounding the passage of the bill. One important source of legislative history are the transcripts of the legislative hearings that were held on the bill. During legislative hearings, lawmakers debate and explain the contents of the bills being enacted. These statements can provide an important indication of what a legislature intended. Another important indication of legislative intent are the documents that were created or used by legislators and their staff as a bill was working its way through the legislature. Often, for example, a criminal law bill will originate in a criminal law committee, and sometimes that committee will publish a report on the bill which gives a greater indication of what the bill's sponsors were thinking. Note, though, that these kinds of legislative materials don't always exist. And even where they do, they usually only reveal the intentions of some lawmakers. For example, the bill's sponsors or most fervent supporters. And yet, criminal bills are given legal force by the votes of all lawmakers. Something to keep in mind as you come across different forms of legislative history throughout the semester. The second source courts consult to assess legislative intent is the common law meaning of terms and phrases in effect at the time a statute was enacted. Under this so-called common law canon, courts presume that the legislature intended for common law terms to be afforded their common law meaning. Here's the idea. Legislatures pass laws in a broader legal context where particular terms and phrases may have a widely accepted meaning. In that case, it seems safe to presume that the legislature intended to incorporate this widely accepted meaning unless the legislature gives some indication to the contrary. I want to illustrate by returning to the vague term of attempt. As I've already mentioned, one way to understand attempt is in terms of whether someone came dangerously close to completing an offense. On this narrow understanding of the term, someone arrested with a gun and mask in the parking lot of a bank would have attempted to commit robbery. But someone who makes a definite plan to rob a bank and then is arrested only right after purchasing a gun and mask would not be sufficiently close to completing bank robbery to be found liable for an attempt. Now contrast this dangerous proximity approach with a broader understanding of the term attempt, which focuses on whether someone made a substantial step towards completing an offense. In the case of this substantial step approach, the defendant in the gun purchase scenario could be convicted for attempting to rob a bank. The common law canon basically says that if nationwide legal practice at the time a vague attempted robbery statute was enacted clearly followed one of these two approaches, so for example, the dangerous proximity test or the substantial step test, then that's the approach courts should presume that the legislature intended to apply, unless there's a clear indication to the contrary. Okay, so consulting legislative history and the common law meaning of terms are two ways that courts try to discern legislative intent. A third is by focusing on the legislature's general or overall purpose in passing a statute. This overarching purpose will be most clear when the legislature is responding to a particular problem. So for example, imagine a high-profile attempted murder case involving a would-be school shooter who the police were forced to let go because he was arrested before he left his house to drive over to the school. Let's assume that this jurisdiction's current attempt doctrine requires dangerous proximity to completion, in which case the would-be school shooter had to be let go. Now imagine that in response to public outrage, the legislature passes a new general attempt statute to ensure that dangerous people like this can't get off. Under these circumstances, one could argue that interpreting the term intent in the new statute to incorporate the substantial step test would be warranted because it reflects the legislature's overall purpose in passing the statute. Now look, in the real world, the dots of legislative purpose rarely connect so cleanly. Most often, there's no specific situation the legislature is responding to. Or even if there is, its relevance to the present case may be unclear. And so the legislature's overall goals are typically going to be abstract and general. For example, something like keeping the public safe or doing justice across certain types of situations. As a result, legislative purpose is most commonly used to support broader interpretations. Here's how this works. A court or prosecutor seeking to persuade one will say that the legislature's overall purpose in passing a criminal statute was to lower the incidence of some kind of criminal conduct, say gun crimes or sex crimes. And so therefore, it makes sense to adopt a broader interpretation of a vague or ambiguous term because doing so will inevitably control crime in one way or another. Note that this doesn't mean the broader interpretation actually will improve public safety. It's simply something that courts and prosecutors say to frame their own policy arguments in terms of legislative purpose. Okay, so we've now covered the three different sources of statutory meaning judges consult to discern legislative intent during the second stage of legal interpretation. They are, again, legislative history, the common law canon, and general legislative purpose. But what happens when these sources fail to provide a clear answer about the meaning of a vague or ambiguous statutory term? At this point, courts are supposed to move on to the third and final stage of interpretation, where they apply something called the rule of lenity. The rule of lenity says that in close cases, where legislative intent is indefinite, courts should construe statutes narrowly in favor of the defendant. This tie goes to the defendant principle basically requires courts to select the narrowest reading of a statute among the viable alternatives. So, for example, if a vague attempt statute could be interpreted to apply broadly to substantial step situations, or to apply narrowly only to dangerous proximity situations, then where legislative intent is unclear, courts should apply the narrower dangerous proximity understanding of the term. This rule of lenity might sound surprising at first, but it makes good sense in light of the legality principle we've been focusing on throughout this lecture. For example, the narrow construction of criminal statutes best promotes fair notice by limiting the surprise of broad interpretations to individual criminal defendants. And the rule of lenity also promotes limited government because it constrains judges from engaging in lawmaking in violation of the separation of powers. Okay, you now have a general overview of the most commonly used method for statutory interpretation in the United States. That method is one which focuses on legislative intent, is consistent with the legality principle, and is most often used by judges to justify the interpretations they offer. It's also the approach to statutory interpretation that lawyers are most likely to have success with in court, and which you're likely to have success with on the exam. Given that reality, we're going to call this methodology the 3 steps to success, and it can be summarized as follows. Step 1. Look to the plain meaning of the terms used as the best indication of legislative intent. If the plain meaning of a statute is clear, then that's the end of the interpretive enterprise. However, if the plain meaning of a statute is unclear, then we move on to the next step of the interpretive process. Step 2. During this step, we consult 3 sources to determine legislative intent: legislative history, the common law meaning of terms and phrases, and the legislature's general purpose in passing the statute. If, after consulting these sources, legislative intent is clear, then you're done. But if legislative intent remains unclear, move on to the next step. Step 3. Here we apply the rule of lenity and select the narrowest reading of a statute among the viable alternatives. That, in short, is the framework we're going to focus on in this class. Over time, we're going to add to it, and we may make some refinements, but on the whole, this is how we'll practice interpreting statutes this semester. As we do so, though, there's something important I want you to keep in mind. Statutory interpretation is as much art as it is science. And so real-world application of our 3 steps to success method, or any other method, allows for a lot of discretion. So you shouldn't expect this framework to provide clear answers to interpretive questions. More than anything, it shapes the language that lawyers use to make arguments and that judges use to justify decisions in criminal cases. This method can easily be manipulated. So, for example, a skillful defense attorney who knows that legislative history and purpose are not on her client's side may try to stretch the plain meaning of a statute to support her cause, arguing something like, there's no need to cloud the meaning of a text that's clear. Conversely, when a thoughtful defense attorney knows that the language of a statute is unhelpful to her client, she might argue that the meaning of statutory terms or phrases are cloudy to begin with. So it's necessary to look to legislative history, purpose, or the common law. Along similar lines, a good advocate will highlight the importance of those sources when they're helpful, and they'll try to minimize them when they aren't. So, for example, a statement in the legislative record contrary to a client's case might be criticized as a single lawmaker's stray remark, not a meaningful expression of the entire legislature's intent. But when there's a stray remark that's helpful, the skillful advocate will highlight the speaker's significance and influence to the development of the bill. And in the worst case, a good advocate will argue that legislative history, purpose, and the common law meaning of terms and phrases are unclear. So it's necessary then to resort to the rule of lenity, in which case the tie goes to the defendant. In theory, this kind of one-sided advocacy might only be appropriate for defense attorneys. But in practice, both prosecutors and judges engage in similar forms of manipulation, whether intentionally or unintentionally. So, for example, even when legislative purpose is unclear, prosecutors have a way of finding support for their preferred broader interpretation through the idea that the legislature generally intended to protect the public, even if there's no good reason to think that the legislature actually intended the prosecutor's preferred interpretation. Likewise, one would think that judges frequently use the rule of lenity to decide cases in favor of defendants. But in reality, that just isn't the case. Although legislative history, purpose, and the common law meanings of terms and phrases often fail to clearly support a single reading, courts seem to have a way of convincing themselves otherwise. So unlike baseball, a tie doesn't always go to the defendant. More often, it goes to a judge's policy preferences, which have a way of shading their view on what legislative intent must have been. So look, these human realities can be frustrating, but they also make statutory interpretation interesting and exciting for those of you who might someday have the opportunity to use your bright, intelligent minds to move the law in your direction. Okay, so that's an overview of statutory interpretation. Before concluding our lecture, I want to discuss an important constitutional limit on the interpretive enterprise, which is grounded in the legality principle, what's called the void for vagueness doctrine. This doctrine recognizes that vagueness is an unavoidable reality of legislative drafting, but it asserts that at some point a statute may be so poorly drafted that it violates due process, and so the statute has to be struck down as unconstitutional. The doctrine has two different applications. The first focuses on the fair notice aspect of legality. The US Supreme Court has determined that a criminal statute has to at least be precise enough to give, quote, sufficient warning that men may conduct themselves so as to avoid that which is forbidden. According to this line of reasoning, a statute is unconstitutionally vague if it fails to, quote, provide a person of ordinary intelligence fair notice of what's prohibited. This fair notice theory of vagueness might seem straightforward in theory, but it's actually pretty challenging to apply in practice. And case law on the topic is also pretty muddy. Courts have made clear that the requirement of due process doesn't require perfect clarity, or even that statutes draw precise lines between criminal and non-criminal conduct. As many courts have stated, quote, those who skate on thin ice can hardly expect to find a sign which will denote the precise spot where they may fall in. That's why there's no constitutional vagueness problem when a statute uses a broad and imprecise moral standard like maliciously or corruptly. Terms like these implicate guilty mental states that well-intending actors are unlikely to skate close to. And all due process requires is for a statute to be clear enough to alert someone who is trying to obey the law to the fact that they're coming close to violating it. That's why constitutional vagueness problems have arisen where criminal laws vaguely prohibit activities that have historically been a part of everyday life. So for example, consider the vagrancy law in the case of Papa Christo v. City of Jacksonville. The law in that case prohibited a person from being a vagrant. Vagrants in turn were described by the law as people such as, quote, rogues and vagabonds, common drunkards, persons wandering or strolling around from place to place without any lawful purpose, habitual loafers, and others. So this language is incredibly unclear. What kinds of people qualify as a common drunkard or a habitual loafer? But in striking down this law as unconstitutionally vague, the US Supreme Court highlighted that people who fit into one or more of these categories might be engaged in completely innocuous and in some cases time-honored activities. For example, going on night walks or hanging out with friends. Because it was unclear whether that innocuous conduct was covered, the court concluded that the law lacked the kind of fair notice required by the Due Process Clause. Apart from a lack of fair notice, the void for vagueness doctrine also applies to statutes that allow for arbitrary and discriminatory enforcement. The animating idea here is that some criminal statutes may become so unclear that they fail to meaningfully constrain government discretion. And that's a problem for anyone who believes in limited government. We don't want to give law enforcement de facto power to lock up whoever they want without any regard for the rule of law. To protect against this abuse of government authority, US constitutional law generally requires that criminal statutes, quote, establish minimal guidelines to govern law enforcement. Without that guidance, a criminal law may be deemed unconstitutional. As the US Supreme Court has phrased it, a statute so vague as to, quote, vest virtually complete discretion in the hands of police to determine whether the suspect has satisfied its requirements violates the Due Process Clause to the 5th and 14th Amendments. To illustrate, consider again the vagrancy law in the case of Papa Christo v. City of Jacksonville. As you might recall, that statute prohibited a person from being a vagrant, understood in terms of rogues and vagabonds, common drunkards, persons wandering or strolling around from place to place without any lawful purpose, and habitual loafers. We already discussed how the court deemed the vagueness of these terms to fail to provide a person of ordinary intelligence fair notice of what's prohibited. But just as important, the court also concluded that the law gave the police and prosecutors virtually unfettered discretion to determine who's a vagrant. One particular concern here, and in other cases, is that law enforcement would bring charges in situations where there are other undisclosed grounds for arrest. For example, the police might choose to stop a person of color, quote, strolling in a white community, a person of low socioeconomic status found in a wealthy area, or members of the LGBT community holding hands because it offends the sensibilities of the officer. So for example, in Papa Cristo, 2 black males and 2 white females were driving together to a nightclub and they were arrested for, quote, prowling by auto. And vagrancy laws were also part of the so-called black codes enacted by some Southern legislatures after the Civil War as an abhorrent means to maintain control over freed slaves. When statutes are so vague that they allow police to target innocent people they want to arrest for discriminatory reasons, those statutes may run into constitutional problems. Please do keep in mind the may here, because whether we're talking about fair notice or discriminatory enforcement theories of vagueness, U.S. constitutional case law is highly uncertain and unpredictable. The void for vagueness doctrine is enforced far less often than one might think, and any defense attorney raising this kind of constitutional claim is likely going to be fighting an uphill battle. But even still, it's an important doctrine to know about, and another helpful illustration of how the legality principle influences criminal policy and practice. Congratulations, you've now made it to the end of this lecture. Now you're ready to see what all these principles and ideas look like in practice. Please keep them in mind as you work through your next set of readings and class assignments.